Hello everyone, my name is Shruthi, a practicing company secretary. In the last 1 month, MCA has issued various circulars for matters relating to companies giving relaxations and extensions. In this video, I'm summarizing 15 such updates from various circulars. To begin with, corporate social responsibility, MCA has clarified which contributions qualify as CSR expenditure. So there is a fund called PM Cares Fund formed on 28th March 2020. The primary objective of this fund is to deal with distress situations like that of Covid-19 pandemic and provide relief to affected people. So the contributions made to this particular PM Cares Fund will qualify as CSR expenditure. Funds that are spent on Covid-19 activities under items 1 and 12 of Schedule 7 of Companies Act 2013 also qualify as CSR expenditure, which are basically for promotion of healthcare, including preventive healthcare and sanitization and disaster management. The contributions made to State Disaster Management Authority will qualify as CSR expenditure. And payment of ex gratia. Ex gratia basically means the moral obligation than any legal requirement. So if there is any ex gratia payment made to the temporary, casual or daily wage workers over and above their disbursement of wages, particularly for fighting COVID-19, is admissible as one-time exception. This has to come with a declaration by the Board of Directors, which is certified by statutory auditor of the company to qualify as CSR expenditure. The contributions which do not qualify as CSR expenditure are Chief Minister's Relief Fund or State Relief Fund for COVID-19, payment of salary and wages to the employees and workers, including contract labor during the lockdown period, and payment of wages to daily wage workers during the lockdown period. Video conferencing for restricted matters. The directors of a company can participate in the board meetings either in person or through video conferencing or any other audiovisual means. There are certain restricted matters which cannot be dealt with at a video conference. Which are these restricted matters? Approval of financial statements, approval of board report, approval of prospectus, consideration of financial statements by audit committee, and matters relating to mergers, demergers, amalgamation, acquisition and takeovers. So now a relaxation is given by MCA for transacting these restricted matters through video conferencing. Only condition is it has to be recorded and stored with date and time. Interval between two board meetings. As per section 173 subsection 1 of Companies Act 2013, minimum of 4 board meetings, that is 1 per quarter, have to happen in a financial year with not more than 120 days between 2 consecutive meetings. But now an additional 60 days time period is allowed for the next 2 quarters till 30th September 2020. Hence, a one-time relaxation is provided with an extended time period of 180 days in between 2 board meetings till 30th September 2020. CFSs and LSS, that is Company Fresh Start Scheme and Limited Liability Partnership Settlement Scheme. Under these 2 schemes, the companies can file forms except for SS7 and charge related forms, and LLPs can file forms 3, 4, 8 and 11 at normal filing fees no matter how old the transaction is. Yes, there is no additional filing fees charged by MCA till 30th September 2020. Directors KYC and active form. Till 30th September 2020, no filing fees will be charged on filing DIR3 KYC and active form, which otherwise was 5,000 and 10,000 respectively. The DINs which are deactivated due to non-filing of DIR3 KYC and companies which are marked as active non-compliant can be reversed and the companies can become compliant again by filing these forms. NCLT matters. All the benches of NCLT are closed and the case is deferred until lockdown continues. However, urgent matters will be heard on video conferencing mode. As regards IBC matters, approval of resolution plan, extension of time and liquidation will not be construed as urgent matters, and these matters will be heard only when the regular benches start functioning. Companies Auditors Report Order 2020. This will be applicable from financial year 2020 and 21 instead of 2019 and 20, which was decided earlier. Now that comes as a huge relief to companies and the auditors. Independent directors meetings. Independent directors are required to hold minimum of one meeting during a financial year without the presence of non-independent directors and members of the company. In this financial year 2019 and 20, if this meeting has not happened, it won't be considered as violation. Maturing deposits. A company which accepts deposits under Section 73 of the Companies Act and maturing in the financial year 2020 and 21 must create a deposit repayment reserve, and 20% of this maturing deposits must be transferred to this reserve before 30th April 2020. Now the relaxation given here is this amount of 20% can be transferred to the reserve before 30th June 2020. Maturing debentures. As per Rule 18 of the Company's Share Capital and Debentures Rule 2014, 15% of the debentures which are maturing in a financial year must be invested or deposited in the specified methods of investments and deposits before 30th April 2020. Now, however, this is extended till 30th June 2020. Declaration of commencement of business. Every company which is incorporated must file a declaration of commencement of business in Form INC 20A with ROC within 180 days of its incorporation. Now, the relaxation given here is an additional period of 180 days is given to these companies to file the same. Resident director. There is a requirement of minimum residency in India to at least one director in a company for a period of 182 days in a financial year. Now, for the financial year 2019 and 20, if this requirement is not complied with, it won't be construed as non-compliance. Convening of EGM for urgent matters through video conferencing. There is no specific provision under Companies Act 2013 for conducting EGMs through video conferencing or any other audiovisual means. Hence, MCA in its recent circular published on 8th April 2020 has allowed conducting EGMs through video conferencing where it is considered unavoidable for holding EGM before 30th June 2020. The conditions for holding the EGM through video conferencing are: the entire meeting has to be recorded and stored. The public companies have to update this recorded transcript on their website. A facility of remote e-voting must be provided and should be in place well before the meeting. Attendance of the members will be counted for the purpose of reckoning the quorum for the meeting. At least one independent director must attend the meeting, and the auditor of the company must attend the meeting or his authorized representative can be present. Appointing a proxy is not allowed. However, appointing an authorized representative to attend the meeting on behalf of a company, a corporate, President of India or governor of the state, if they are members, is allowed. The resolution passed in this meeting, whether ordinary or special, must be filed with the Registrar of Companies within 60 days of passing such resolution. So these are the 15 updates from various circulars in the last 1 month. I trust the information shared is helpful to you. Thank you for your time. Have a good day.